So we have reached the top of the hour. It's our last time slot for day one of the Peralta Online Equity Conference. We're here with Lizzette Herrera Castellanos, and I'm so pleased that you're able to join us, both you, the presenter, and all the participants. Before we get started, I want to just share a couple of housekeeping tips. One, if you would like to use the captions, they have been enabled. All you have to do is go down to the toolbar at the bottom of the Zoom window and select either the captions button, or sometimes it's hidden in the button that says more with 3 dots. And then you choose the captions item from that menu and you're off and running. Next, there will be time for questions. We will stop the recording at 4:30 so that people can ask questions that might be of a personal nature or identify them in some way. So, but we also can use the chat to ask questions so that Lizzette is ready for them when she gets to that period. And then last but not least, because this is being recorded, welcome to all of you who are watching the recording in the future. We are here in the present and looking forward to this session. So, Lizzette, I'm going to hand the microphone over to you to introduce yourself, your topic, and then just remind me when you'd like to stop the recording so that we can have the Q&A.
Perfect. Hello, everyone. My name is Lizzette Herrera Castellanos. I am a professor at Southwestern College in San Diego, California, as well as Miracosta College in Oceanside. So I'm going to start to share my screen. So if you all will give me 1 second. One more time. All righty. So isn't this always the way, right? Slideshow. All righty. So, ladies and gentlemen, my name is Lizzette Herrera Castellanos. I am an attorney, but I need to give you a little bit of background on who I am and why I chose to give this session. So, about me, if you'll just bear with me, I was actually an adjunct professor for pretty much 20 years at the community college. I was a practicing attorney. I worked at the law school level as an administrator. And as an adjunct professor, you become very keenly aware of, am I going to get assigned this class next time? Am I going to be told, like, this is the same prep that I got to do? Um, is somebody going to steal my class when they come in? Is somebody going to take my class and then, they could use it wherever? So I'd like to do a very quick poll of everyone in here. I have, I think, about 10 people in here. I'm curious, if you are an adjunct faculty member, let me know by putting a thumbs up. Okay, 1. So Kevin, I'm with you. I was there for 20 years. So this is very much a concern for adjunct faculty members. But this is what I want you to realize. I did work as an attorney in the San Diego legal community for several years. I was very involved. And then I really got into online learning probably around the time that, we were starting out. It was about 2005. I've been doing it, seriously for about 20 years now. And I decided I was going to become a really good professor when I realized I could be home with my kids and be an online professor and also practice law in terms of what I wanted to do. So while I was home with my kids, when they were very little, they were babies, I was still, straddling the world of the law school level, practicing, teaching at the community college. And I decided to transition out of the practice of law for a little while. And I was told by a president of the union, they said, why don't you join me and you could be a grievance officer? And I thought, what exactly is that? And it's when faculty have concerns about their contract, their employment, any issue that may come up. And more often than not, I had several faculty that came to me and said, I feel like my classes are being taken from me. I've already prepped the class, and then I don't get the class back. But the other thing that was interesting was I had professors that would say to me, I had somebody that came in to an evaluation, they evaluated me, and I feel like they took the work that I was creating and kind of took that concept with them. And so because of that, I also became an online mentor. So I became an online mentor because I wanted to see what other people were doing, because I also wanted to follow what they were doing. But I wasn't necessarily going to take anything without talking to them. Then I started to receive emails from other faculty when I became a full-time professor, and they actually were asking me, hey, can I have a copy of your course? And I was always shocked that people would be that blatant about it. Can I have a copy of your course? Now, let's do another, impromptu poll. How many of you in here, let's do a thumbs up, how many of you in here would hand someone a copy of your course? All right. So no one in and you're there's a reason you all do it. Now, Kevin, let me ask you, why would you be okay with it?
After teaching for 25 years, I've built a course that rather than, because I own the intellectual property, I want to release it as a Creative Commons work. So I get
Mhm.
attribution, but others can use it to further the discipline
Build
and
upon.
yeah.
Now, that you bring up a great point, Kevin, because I have a lot of faculty that are, at the tail end of their career, and they're like, well, what's the big deal, Lisette? And it is not such a huge deal to faculty that are on their way out as it is to faculty that are on their way in. But there's also a generational divide. Now, I'm not going to cover the generational divide as much as I'm going to cover what your legal rights are, because I want you to know what your legal rights are. All right. What you need to know about me is these are all the roles I've held. So, in essence, I'm a unicorn. All right. I'm like this weird mix of like professor that taught online, but I'm an attorney, but I handled grievance matters. So you need to know this about me so you understand where I'm coming from. And I'm going to be discussing several cases that I've actually headed up so you understand what my concerns are. Now, before I begin, I want you all to realize that we're going to be talking about two areas of law here. The first one is intellectual property, and the second one is employment law. So I'm going to cover intellectual property first. All right. Intellectual property is anything created with cognitive processes by an individual. Now, years ago, I would have told students that the most valuable thing that they will ever have are the houses they own, the cars they own, the assets that they have that, stocks, bonds, whatever it may be. And over time, I've come to realize that the most valuable things that we own, the most valuable asset that we tend to have, are the cognitive processes and the creations that we have made. All right. And so as a result, I have to tell people, look, what you create has value, but it depends on how much value and who is willing to pay for it. So anytime we talk about IP rights, intellectual property rights, this means that you can sell, copy, parody, sample the work. You can do whatever you want with your intellectual property. So let's say that you are teaching at Peralta and you decide that you're going to come over to San Diego and teach it at Miracosta. Your class, you would just want to pick it up out of Canvas and copy it over into another Canvas, right? The other school's Canvas. You have a right to do that. You have a right to do that because it tends to be your own intellectual property with some limitations. Now, let me tell you about the different types of intellectual property. So we're going to focus on copyrights in here. But for the most part, anytime we talk about IP rights, we're talking about patents. Does anyone know what patents are for? Yes, they are for inventions. Yes, very much so. So patents are for inventions. Now, these inventions don't necessarily affect us unless you're thinking about, you develop the latest and greatest, form of electric motor or the latest and greatest, cancer treatment. All right. Those tend to be patents. Trademarks are logos or symbols of a company. So I have a professor that I taught with for, 15 years, and he teaches financial investments and personal finance. And he has a logo for his website that's called Wonder Professor. And he has a logo for it. And I'm always like, that's amazing. Like, who would think a professor would have a trademark? He protects it. He actually, filed for the trademark. Then we get into copyrights. Now, copyrights are for any original work that you create. Now, how many of you, let's do a poll again, how many of you use publisher material? Any sort of publisher material? Okay, that would likely be most of us. Most of us use some sort, like we're not, does anyone ever, start a class at zero and say, I'm going to write the textbook, or you're using my textbook? Okay, that tends to be few and far between. But if you're doing it, that's exactly the type of work that you would protect. If you are actually drafting your own textbook, your own materials, that is your work. All right. So let me get into a little bit of employment law, because we're going to come back to intellectual property repeatedly. Okay. Let me see. I have to get out of there. Okay. Sorry, gang. There it is. Okay. Okay. So I have to give you a background on employment law basics as well. All of us in here, whether we choose it or not, we belong to a union, and the union defends our rights. Even if you're like, I don't want to be a paying member, they still represent you. All right. And the reason that that's important is because the unions are the exclusive unit to negotiate with the district. Okay. And I tell you this because I always have somebody that's like, well, I don't pay my union dues. They're expensive. But the reality is that our unions are the exclusive body that can negotiate with the district. All right. So your largest source of rights is found in your union contract. And I'm going to show you a sample contract in a minute. But when I cover the IP contract language, you're going to be shocked, because if you actually went to your contract, some contracts never mention intellectual property rights. They never mention them. And it's not very clear based on our contract who owns the IP rights. So what I generally tell people is, if you are going to be looking at your contract to see if you have intellectual property rights and the information is not there, there are also board policies and administrative policies that exist at your institution. So you should be checking those as well. You are looking for a source of intellectual property rights. If you do not find it, we'll have that discussion, as soon as we turn the recording off. But if you do not find those rights in your contract, I wouldn't necessarily worry. But my hope is that eventually those would be there. What I want you to realize, though, is that probably around 2010, 2012, we started to realize that there were a lot of rights and there was a lot of power in these online courses. Why? People were taking courses across the country at, those massive online course offerings. People were, putting their courses on Coursera. They were putting their courses online for people to take because they wanted to, teach or make extra income on the side. So some of the community colleges in California did start to put the IP language in there, and they were slowly whittling away the rights as authors. Now, the problem is that even if they're taking some of our rights, and you're thinking, well, what hope do I have here? We still have a lot of hope because of what we create and the work we put into our classes. Classes don't give themselves. If somebody has a discussion board, you have to monitor that discussion board, and you have to know how to respond to student, answers, student questions, student, issues that come up. That is where our value lies. So I'm going to actually show you this contract language. This is actually from my contract at Southwestern College. And I was shocked when I found this the first time years ago, because what I want you to realize is that during COVID, people were throwing stuff up onto Canvas left and right. Correct? Everybody, let me just throw something up there because I've got to get something into my Canvas course shell. So what you want to do is you want to check the contract and see what it says. if it says something, here's the easy way to go. This is the easiest example I could give you. This is my contract at Southwestern College. A unit member who is the creator of an academic work or the owner of that copyright or the owner of the copyright for that work, including work created within the unit member's scope of employment. An exception is, oh, sorry, owns the copyright for that work, including work created within the unit member's scope of employment. Now, this is extraordinary. I don't expect this to exist in all contracts. Sorry, I'm moving the Zoom screen around so I can read this full thing. This doesn't exist in all contracts, ladies and gentlemen. Sometimes it'll exist in your contract and it'll have limiting language. And you'll see the limiting language that'll say something along the lines of work created in conjunction with your scope of employment is the sole property of the district. Now, at this point, you should be asking me, well, can they do that? And what I generally tell faculty is they can up to a certain point, and it depends on how much they want to pursue this. So I had a case of a faculty member, it was a couple years ago, and she was adamant that her work had been lifted out of her class without her permission. And I said to her, what do you think they took? And she said, I think they took a particular worksheet because I created that worksheet. And I said, okay, hold on, let me get an access report. And I said, who has been allowed in your course shell? And she said, well, I think the dean went in after, I took a semester off. And I said, okay, there's no problem. So I asked for an access report from the Online Learning Center director, and I have an excellent Online Learning Center director. She's God's gift to this green earth. They do not pay her enough. And so I ended up telling her, look, I found the access report. It doesn't show that anyone was in your class during this time period. So, and so since no one was in your class during this time period, I doubt it was lifted. She kept on insisting that it had been lifted. So then I said, okay, there's no problem. Where do you think it's being used? And she thought it was being used in her department. So then I wrote an email to the dean, and all I had to do was cite this language. Please remember that a unit member who is the creator of an academic work owns the copyright for that work, including work created within the union member's scope of employment. All right, cited that exact language. Even if I did not have this language, even if it said that under the scope of employment, the district owns the work, that still does not allow somebody the right to enter your class. Because at that point, I'm going to go back and look at the evaluation, the access, what exactly it is that they're taking. Because not all of us are submitting our classes to the United States Copyright Office, our works may not necessarily be copyrighted, but we still have rights as creators. All right. And again, I covered two areas of law, intellectual property and employment contracts. So under our employment contract, we still have rights to the work that we create. And some of it is based off privacy rights, but I want to be clear that we have rights in the material that we create that we can do what we want with it. Now, does anyone in here know what a non-compete clause is? Anyone? Okay, I'm going to tell you guys. Oh, you do. Kevin, tell me what a non-compete clause is.
Well, in work I've done as a consultant, they have told me that in my agreement that I will not do work for an organization that is a competitor to the organization I'm working with. And so I imagine in this case, it might be as an instructor that I would not compete with organizations that have similar missions or things like that.
Right. So you know what, Kevin, your situation as a consultant is very unique because if you're working on a particular type of consulting project, California will allow non-compete clauses for certain industries. They will allow it for certain industries. And what I like to tell people is, look, you go work as an engineer for Apple, they may put a non-compete clause because you're working on something very, very specific, and they will not let you go work for Google. And so there's this funny, I read this meme the other day where it was Steve Jobs, writing a letter over to I forget which firm it was, like if it was Google or if it was, AT&T or some other firm. And Steve Jobs was saying, I realize that you are coming after our employees. We have a very clear policy not to go after other people's employees. Please let me know if I need to change my policy or you need to change yours. And the reality is that there are certain people that are skilled in a particular area that we don't want to compete with them later on. So that's where the idea of non-compete clause comes up. Non-compete clauses are clauses found in contracts that limit where you can work for a specified period of time. So, can someone put in a non-compete clause, you cannot work for our competitor for the next 10 years? No, no. They have to be reasonable in length of time. They have to be reasonable in terms of, who you're limiting. We don't like to limit people here in the US. In California, Gavin Newsom, our current governor, was so adamant that he did not like non-compete clauses that even if you come from a different state and you come to California, those clauses that may be in a contract in another state, that non-compete clause does not apply in California. Okay, so the reason I bring this up is that this is an area of state law that is incredibly clear. And thankfully, at the community college level, we don't have non-compete clauses. So you can literally lift your class from one institution and take it to another. Now, what I want you to realize is that a lot of businesses still put them in their contracts. They do. But what you have to know about employment law is that if you are paid for your work to create a class, that is when there is a more likely chance that your institution is going to own that material and limit your use of the material. So has anyone in here ever created a class for like CCC, OEI, or you've been paid to develop a class because your department got some money and they needed somebody to develop the class that everyone could use? Let me see thumbs up if you've done that. Okay, I've done it. I actually created a course for CCC OEI. I received a grant for it. It was a legal research class, and I created the class, and now people are able to access it. Do I own the rights in those materials still? To a limited degree. As a culmination, that class can now be downloaded. Now, some of you in here have told me, okay, no, I've never done that. How many of you have put information into Canvas Commons? One. Anyone else? Let me see thumbs up. Two. Adriana, you put something into Canvas Commons. Did you put a whole course in or did you just put a couple items in?
No, just a couple items. I'm an instructional technologist, so just things that everyone can use in their classes. But we do help faculty like share things into the commons. It's actually part of even our poker process locally that if you go through the alignment that, we hope you share your class to the commons. So
Yes. Yes, very much so. So here's the thing. I've always encouraged faculty that are adjuncts to share pieces of their class. Meanwhile, I tell full-time faculty, share your whole class. Share your whole class because you're being paid for the whole class, and ultimately you have the bandwidth as a full-time faculty member to share that whole class with another faculty member. It's funny how when I went through the transition from being an adjunct faculty member to being a full-time faculty member, I had a mind shift because I was being guaranteed my classes. Because I felt like, oh, okay, now I can share and I feel more open to sharing because I get my classes and hey, you want an overload, Lizzette? But adjunct faculty members have a different sort of mindset around that. And the reason that I understand that mindset is because you worry about getting your next set of classes. All right. The reason I put this whole section on non-compete clauses in my presentation is because I want adjunct faculty members to realize you can take your class and take it somewhere else. But the reality is do you own all of it? Not quite. The publisher probably provided certain materials. The, PowerPoints, you may have, taken portions of the PowerPoints. Faculty are not always saying, oh, look, here, I lifted this from the publisher textbook, or, I got this activity from the actual publisher's book. But the reality is we are pulling from that. And we would be using those publisher materials no matter where we go. Sorry, my next. Okay, so this is what I was talking about where faculty can work at other jobs. They can. And so there was a big case recently. It was about 10 years ago. It was at Stanford. And we actually had a Stanford researcher that developed it was actually a form of HIV testing to make sure that you could detect the HIV virus in blood. And the pharmaceutical company that started using it said, we can use it because this faculty member developed it. And Stanford said, no, we own it. And the reality is that this went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court said, authors, it vests in authors first. That was for patents. But the reality is that we become authors of our own courses. All right. And as an author, there's a lot of strength in what you can do. But I want to be clear that even though there's a lot of strength in what you can do, these are the questions I need you to ask yourself. First of all, what does my contract say? Because if the institution has been burned before, they may have put in language that's starting to limit intellectual property rights. But even if your contract is trying to limit intellectual property rights, sometimes they're not that worried about the discussion board that you have posted, in your accounting 101 class. They may not necessarily see the value in that. So that doesn't mean that you can never use it again. All right. There is the reliance on the institution to move to protect works that they feel are copyrighted. The other example I like to give is anytime faculty go on sabbatical, they usually submit a topic. And when they submit a topic that, I'm going to write the guidebook on, how to create internships and connections in the community. The institution is paying you for the sabbatical. They will own what you created. Does that mean you can never take that and, adjust it and take it elsewhere? This is very similar to Taylor Swift. I don't know if you guys know, but Taylor Swift, her catalog got sold, and she went on. Whose show did she go on? I believe it was one of the talk show hosts, Kelly Clarkson, maybe. And I read about how brilliant it was that Kelly Clarkson is like, well, they took all of your recordings from before. Why don't you just re-record everything, and you'll own the rights to those second set of re-recordings? And she did. That's exactly what Taylor Swift did. Taylor Swift is, like she doesn't have enough money because my kids want, her music. So she did. It's the same concept here, ladies and gentlemen. If you decide that you're going to take it somewhere else and the institution has not necessarily followed through on taking that material, past practices is also very big in employment law. Past practices will tell us what is allowed to happen and what is not allowed to happen. If they have never enforced, keeping certain materials, it is less likely that they will do so in the future. All right, number 3, was I paid to develop the course? If you were paid to develop the course, you likely do not own the course. Does that still limit you from using the material? No. For example, when Adriana was asking, when she was telling us about, the fact that she encourages people to put her materials up in Canvas Commons, that's actually why we're paid to develop courses. We are paid to put these courses, into Canvas Commons. We're encouraged to put them there so people can use them. That includes you. That includes us as faculty. So you can still use those materials. Is the course made up of publisher materials? I had another faculty member that was pretty adamant that they had created this class, that they had intellectual property rights in this class, and they were adamant that they had actually created, it was a handout. And when push came to shove, I contacted the online learning team. I said, you know what, I've got this grievance. Could you walk me through the course? And they walked me through the course. And, again, I said, let me see who's been in there. Let me see who's accessed the materials. Checked it. Then I figured out that the material that the professor was saying was there was actually material created by the publisher. And the professor did not have an intellectual property interest in publisher materials. Now, does that mean, okay, well then I'm shot to hell because I've got, publisher material all over my class? No. It's never a clear yes or no. It's actual specific materials that you may have intellectual property rights in. So even if you use some materials but not others, the culmination of materials into one course shell does have intellectual property value, but it depends on how much you are taking and how much you create. So there's never a yes or no answer. And I feel like such an attorney right now. Like, I can't say yes, I can't say no, I need to ask you more questions, but that's the reality. All right. The other thing that I say is, who did I give access to these materials that I created? So I had a case where I had a professor that created a class. She was very nice, gave a copy of her course to someone in her department. The person in the department then posted it on Canvas Commons, and the professor was not happy about it. And she came to me and she said, are they allowed to do this? And I said, you know what? It's a matter of them being given access to your materials. Have they adjusted it? And have you spoken with them? So I had a whole conversation in terms of what it is that they were allowed to do and not allowed to do. What I did is I actually brought them together. We had a discussion. I mediated a discussion, and she said, you know what? I'd be okay with you posting most of the publisher material, but some of my material, I'd like you to take it down. And she did. She took it down. So why do I want to own my class? Like I said, there is value in your actual cognitive processes. So that becomes very important to you in the long run. Okay, that being said, I am going to run through the protections and then we'll do, 10, 15 minutes of questions. So protections, share parts of your course, not the whole course. All right, so it's always better if you share one activity or one, worksheet versus the whole course. And the reason I'm pretty adamant about this is because you want to make sure that if you are sharing the whole course, the course is complete. The course is complete, there's information on it, and there's certain things that, I even do this. I post things and I think the students will understand it, and then, they're asking me constantly for clarifications. So you always want to post things in parts because you want to make sure that you're posting the best of what you've got. That's making sense with students. How many of you download a copy of the course at the end of every semester? Of course you do, Kevin. Anyone else? Thumbs up. Okay. I have to tell you guys, I'm with you. Like, sometimes the end of the semester comes and you're literally like, damn it, I just turned in grades, we're done. And the reality is you should be downloading a copy of the course at the end of the semester, every semester, because that's where your intellectual property lies and you want to have access to it. Out of curiosity, Kevin, where do you download it into? Do you do a Google Drive or what do you do?
Locally to my computer so that I
Okay.
can use it for other instances and things like that.
Okay. I always recommend putting it up on the cloud even, or like having, in a particular Google Drive. I pay the extra for the Google Drive because I have a fear of losing my documents because I've had computers crash. But remember, intellectual property has certain rights as long as you're protecting those rights. Okay. Distinguish between what you created and what you used from the publisher. Remember, you don't have intellectual property rights in terms of what you had with the publisher, what you used from the publisher. You have intellectual property rights in terms of what you've created as a whole. And again, it depends on how much you've created and how much you've used from the textbook, the publisher, online. All right, understand that even if you use publisher material, the way you put it together has some intellectual property value. And then, we talked about Canvas Commons. All right, I feel like I've covered quite a bit here. And so I thank you all for sitting tight with me. Kevin is going to turn off the recording now, and I want you all to feel free to ask questions. And it's only because, and I would like to say that my disclaimer is, I am not giving out legal advice. This is, general information that I can give you all in terms of what I've seen in grievance cases, what I've seen in terms of protections, and what it is that this could be used for. All right. So if you guys have any questions, Kevin will turn off the recording and we can all have a chat.
Before I do you want to share, and this is up to you, any contact information for people watching the recording who might not get a chance to ask you a question live?
Yes. You know what? I'll put my email in the chat, but it is Herrera, HERRERA at swccd.edu. And feel free to reach out to me if you should have any questions.
Perfect. All right.
Thank you,
Well,
Kevin.
so I'm going to thank you now, even though we're going to have some more fun together. But thank you so much for sharing really important information about our rights as instructors. And so I'm going to stop the recording and look forward to seeing everybody tomorrow at the conference.